I watched the judge lift his glasses, stare at the deed my stepmother recorded 2 weeks before my father died, and ask her lawyer one small, lethal question. Where in this power of attorney does it say she can give herself the house? The answer cracked the room open. A door I thought was welded shut swung straight toward me. If you clicked on a story promising that a woman tried to erase me from a $450,000 inheritance and I turned it around with a single clause and a recording, you're in exactly the right place. I run a channel called After Her Lies, and this is the case that taught me what family, money, and justice look like when the spotlight is a fluorescent ceiling and the mic is a court reporter's machine. My name is Emily Hart. I'm 34, born in Dayton, Ohio, and I make videos that pull the curtain back on the quiet wars we fight in kitchens, funeral parlors, and county courthouses. The she in After Her Lies is my stepmother, Linda, who married my dad when I was 17. Dad, Dennis Hart, owned a small HVAC business and spent more of his life in crawl spaces than on couches. He and Linda were together for 17 years. He died on May 10, 2024, at Miami Valley Hospital, a little after 6 in the morning. The stakes were clean and brutal. The family home on Willow Bend listed at $389,000, a brokerage account that passed outside probate but was supposed to be split, and the real flashpoint, $450,000 in proceeds from the planned sale of his business that Dad had earmarked in writing for me and my brother, Evan. Wrapped around those numbers were official papers with teeth, a will dated February 14, 2020, a revocable living trust amended October 28, 2023, and a durable power of attorney signed, allegedly, on February 2, 2024. On the day we met at the funeral home, Linda hugged me like a person who owned the place. The first slice of injustice was quiet, like a whisper no one else hears. She stood with the funeral director discussing casket sprays and the memorial program while I scanned the invoice. The words "Estate of Dennis Hart" jumped out next to a deposit line already paid with Dad's checking account, ending in 45.21, an account I didn't know she had added herself to in March. When I asked her about it, she smiled in that way that says, "Both I expected you to ask and your question doesn't matter." Then she said the line I will hear forever. "Your father wanted things simple. He put me in charge of everything." Simple is a knife if you let it be. In the weeks after Dad's funeral, the pressure built in public ways that left me red-faced in places where you shouldn't have to defend your relationship to your own father. At the graveside service, Linda told people she'd be selling the house as soon as the market cooled from the spring frenzy. My Aunt Ruth gasped, because Dad had always said the house would stay in the family. At the luncheon afterward, Linda cornered Evan near the coffee urns and said, "Lo, you'll get your keepsakes. Don't make this harder than it has to be." Keepsakes, as if the mortgage had ever cared about our feelings. I made mistakes at first. I thought I could reason with a person who'd already made a legal plan without me in the room. I asked Linda for a copy of Dad's will. She said she'd locate it after the weekend. I asked about the trust. She said, "There's a binder somewhere." 2 weeks passed, no binder. Instead, I got a notarized letter from a title company attached to a deed recorded April 26, 2024. It moved the house from Dennis Hart, trustee of the Hart Family Trust dated 21/4/2020, to Linda Hart, spouse, for $10 and love. $10 and love is what people write when they don't want you to think about the law. The first official blow landed like a rubber stamp. On June 3rd, a beige envelope from the Montgomery County Probate Court arrived, addressed to interested parties. The caption read, in the matter of the estate of Dennis Hart, deceased, case number 2024 PR 1128. Inside, a notice that Linda had applied to administer the estate and that the will would be presented on June 20th at 9 a.m. The will, finally. Except the moment I read the words, application to probate will, my stomach dropped. If the house was already out of the trust by deed, the will's plan might be an empty box. Before June 20th, I did what I tell my audience in every video to do. I gathered paper, I made lists, I kept my voice level. I walked into the attorney's office where Dad had drafted his plan and asked for the client file. They would not give it to me because I was not the personal representative. But the legal assistant, a woman with a rosary bracelet and a spine of steel, told me what I needed to hear without violating privilege. If you believe assets were moved improperly under a power of attorney, you'll want to look at the language about self-dealing. Ohio adopted the Uniform Power of Attorney Act in 2012. I went home with that phrase self-dealing like it was the name of a person I needed to find. Every time Linda ignored a text about Dad's watch, she found time to post on Facebook about starting fresh and renovations. She took a photo in the living room with paint swatches taped to the mantel, my childhood photos stacked in a cardboard box in the background. The comments were full of heart emojis and the sentence that makes blood pressure monitors explode. You deserve this. I commented only once, and I deleted it. It's not yours. It wasn't useful, and Linda took a screenshot anyway. The first obstacle hit me in the bank lobby. I had made an appointment to speak to the branch manager about an account statement from April. Linda had used the power of attorney on February 2nd to add herself as joint on Dad's checking and savings, and then on April 18th, she cut a cashier's check for $25,000 to a contractor. The manager was polite, polished, and shut. I can't discuss a living client's accounts without authorization, he said. He died last month, I said. He repeated the rule. I called Evan from the parking lot, and we sat in the car and cried. Then I dialed a probate attorney whose consultation fee, $320 for 1 hour, felt like buying oxygen in a room that should have had air. During that hour, I learned to stop saying feelings and start saying facts. The attorney's name was Caroline McGinn, and she chewed a pen while she listened. She explained that if a person holding a power of attorney transfers assets to herself without explicit authority, a court can classify it as voidable self-dealing. She told me to get the power of attorney document and look for a gifting clause, and more specifically, language authorizing gifts to the agent herself. If it wasn't there, that deed could be undone. Then she said, "But you'll need evidence, notaries, recordings, witnesses." Evidence is not a moral victory. It is a paperclips and staples game that can beat a betrayal if you play it carefully. That night, I opened the voice memos on my phone and found the recording I had almost deleted in grief. On May 1st at 8:12 p.m., the week before he died, Dad had called me from the hospital. He sounded thin and wet, like memories being wrung out. I had recorded it because I record everything when I am scared I will forget. He said, "Emily, tell Evan when the business sale closes, it's for you two. Linda gets the house to live in. She'll be okay, but that money is yours. It's in the trust. Ask Sheila about Schedule B. There's a list." Sheila was the paralegal. Schedule B was where assets were listed beneath the trust. The list that mattered. The second obstacle was older and deeper. People don't like to think badly of a widow. When I told Aunt Ruth that I was going to contest the deed, she drew back like I had threatened to push Linda into traffic. "Your father loved that woman," she said. Don't put him on trial. I'm not, I said. I'm putting the paper on trial. People hear what they've been trained to hear. To build a plan good enough to beat both the paper and the size from the pews, I needed two things: the power of attorney document itself and the trust's Schedule B. I couldn't get the law firm's file, but I could get public records. The deed was already recorded, and the instrument they'd attached was the power of attorney. I drove to the recorder's office on Salem Avenue with a flash drive, and my heart trying to exit through my throat. The clerk pulled it up on her monitor. Durable Power of Attorney of Dennis Hart, notarized February 2, 2024 at 3:41 p.m., signed at Hart Residence 215 Willow Bend. I asked for a certified copy. She slid it under the glass. In the parking lot, I read it once as a daughter and once as a person learning to read like a judge. The gifting section allowed gifts to the principal's descendants and charities. It said nothing about gifts to the agent. There was a separate section titled Hot Powers, where you initial to permit scary things changing beneficiary designations, creating trusts, amending trusts. Dad's initials were present next to Create Trust, Amend Trust, and Make Gifts, but not next to Self-Dealing by Agent. I turned the pages over like that missing initial might flutter down. It didn't. On page 7, there was a sentence about fiduciary duty. The agent shall act in the principal's best interest and avoid conflicts, including transactions with the agent. My throat loosened. The oxygen I had bought was working. The second part, the list was harder. When a trust is created, the property titled into it is often listed on a Schedule A or B attached to the trust. That schedule is not always recorded anywhere. But Dad had told me to ask Sheila. I couldn't get the firm's file, but I could subpoena the schedule later. For now, I needed a breadcrumb. I went through Dad's office. There, under 3 HVAC invoices and a paperclip that had rusted into the desk grain, was a photocopy with the words Hart Family Trust, Schedule B at the top. List item number 1, residence at 215 Willow Bend, see deed dated 20/4/2020. Number 2, Hart Heating and Cooling to be sold, proceeds to trust beneficiaries. Beneficiaries, itemized below, children of the grantor, Emily Hart and Evan Hart, share and share alike. My hands shook. It felt like holding the will itself. I made a scan and put the original back exactly where I found it. I am my father's daughter. We both know paper matters. On June 20th, the probate courtroom looked like a school library where no one smiles. The hearing was set for 9 a.m., and the docket was a page thick. When our case was called, the judge, a woman named Honorable Patricia Mayo, said good morning with the kind of patience that makes babies stop crying. Linda's attorney, a tall man with hair like a commercial, introduced himself as counsel for the applicant, Linda Hart. I stood when my name was called, introduced Emily Hart, interested party, and tried to lock my knees without looking like I was locking my knees. The will was admitted with the efficiency of people who do this before lunch and after coffee. It left the residue of Dad's estate to the trust. That mattered because it meant the trust controlled distribution, not the will itself. Then came the part I had been waiting for since the day I saw love and $10 on a public deed. The judge said, I understand there is a dispute regarding a transfer executed under a power of attorney prior to the decedent's death. Linda's lawyer stood, voice silky. There is no dispute, Your Honor. The decedent conveyed the residence to my client in legitimate recognition of their long marriage. He placed his hand on the stack of papers like he was blessing them. Caroline, my attorney for that day only. I had scraped the retainer together from my emergency fund stood. She said, Your Honour, we move to set aside the deed recorded April 26, 2024, on the basis that the agent under power of attorney lacked authority to self-deal. The gift exceeded the annual federal gift exclusion without any written consent, and the transfer violated the trust's express terms, requiring the residents to remain trust property until distribution to the beneficiaries. She handed up the certified copy of the POA and the Schedule B copy as an exhibit. The judge put on her glasses and read. The room breathed through the HVAC vents. Dad would have tuned in 5 minutes. Linda's attorney argued that as the surviving spouse, she was entitled to statutory allowances and the house, and that Dad intended her to have it. He said the phrase meant to win all arguments in American kitchens. He told her. The judge nodded and then asked the question that broke the air open. Counsel, can you direct me to the line in this instrument that authorizes your client to make a gift to herself? He turned the pages the way a person searches for a fire extinguisher that isn't in the kitchen. He pointed to the General Gifting Authority. She shook her head. To herself. He paused, smiled politely, and said he'd need to brief it. The judge nodded again, slower. We will take testimony. Then came my part. I wasn't just a camera anymore. I was the witness I kept telling other people to become. When Caroline asked if I had any recordings of Dad's intentions regarding the business sale proceeds and the house, I said yes. She played the 8:12 p.m. recording. The court reporter typed the words out like pearls sliding onto a thread. Linda didn't look at me. She looked at the carpet. When the word Schedule B came out of the speakers, a bailiff I hadn't noticed looked up. The judge asked me how I found the Schedule B copy. I told the truth. Dad's office, a drawer, under invoices. I said I had returned the original and brought a scan. The judge made a face that said a tidy person appreciates a tidy narrative. Then she asked the question that could have sunk me. Ms. Hart, do you understand that a copy of a schedule is not the same as the schedule attached to the trust at execution? I said yes. Caroline jumped in. Your Honour, we have issued a subpoena to the drafting firm for the trust schedules and related correspondence reflecting the intent and the asset list. We also have the Recorder's Office records showing the house was deeded into the trust on February 14th, 2020. She handed up that deed. The judge read again. And then, because Linda had not imagined I could be boring and relentless for long enough, I used the second leverage I had held close. I had spoken to the notary whose seal appeared on the power of attorney. She remembered because February 2nd had been an ice storm. Her journal said she went to the Hart residence at 3:00 p.m., saw Dad, and asked him to verify ID and state the date. She had written confused about day, but oriented to person and place. Not a knockout, but she also wrote, agent asked whether this allows her to change title. I advised I cannot give legal advice and she should consult counsel. She was careful. She was honest. She had no dog in this fight. We had subpoenaed her journal entry. It was in front of Judge Mayo now. In the middle of Caroline's next question, the judge held up a finger and looked at Linda's lawyer. Counsel, I would like you to explain how, in the absence of explicit authorization for self-dealing, your client used the power to transfer trust property to herself, where the trust schedule shows the property as a trust asset. He said he would need to brief it. She said, you shall. She set a deadline, July 8th. I went home and cleaned my sink like the verdict was hiding in the drain. Then I drafted the video outline I thought I'd never publish. I called it the clause that beat a deed. I recorded voiceover at 2 a.m. because that's when grief and adrenaline take turns at the wheel and my apartment is quiet. I explained the difference between a will and a trust, how a pour-over will captures residue and feeds it to the trust, what a durable power of attorney can and cannot do, and why Schedule B matters. I cut from my narration to B-roll of my fingers flipping through a blank legal pad. I sharpened a pencil on camera. I did not cry on camera. I saved that for the space between exporting and sleeping. On July 8th, Linda's lawyer filed a brief. He argued that the gifting power in the POA gave broad authority, that as a spouse Linda's aiding of herself was within Dad's intent, and that the deed should stand because equity favors those who are already in possession. Caroline filed our response. She cited Ohio Revised Code Section 11837, 42 and 1337. 36 pointed to the lack of a self-dealing clause and attached affidavits from me and Evan, the notary's journal, and a letter from Sheila, the paralegal, authenticating Schedule B and attesting to Dad's instruction in October 2023 that the residence should remain trust property through distribution to the children. Sheila's letter was careful, signed in blue ink, and notarized on July 2, 2024. It did not read like revenge. It read like a calendar entry turned into a sentence. When we returned to court on July 16th, the gallery held 4 strangers from earlier cases. Aunt Ruth in a blouse with tiny cherries, Evan with his jaw set so hard a dentist could have hung a painting from it, and a title rep sitting in the back because she smelled a cloud on a chain of title. The judge took the bench. "Counsel, I've read your briefs. Miss Hart, I've listened again to the recording." She looked at Linda then, and it wasn't pity or anger. It was a look I have come to recognize from the bench, a weighing that doesn't care if you're crying. And then she said, "The power of attorney does not authorize the agent to make gifts to herself. The agent's transfer of trust property to herself is an act of self-dealing and is voidable. The trust Schedule B reflects the residence as a trust asset. It is the order of this court that the deed recorded April 26, 2024 is set aside. Title is restored to the trust." The sound in the room was not applause. It was air being breathed by people who had been holding it too long. 2 more things happened in that hearing that matter as much as the order itself. First, the judge set the path for the business sale proceeds. The buyer had deposited $450,000 into escrow on May 3rd, and it had been waiting. Linda's lawyer argued she should receive the marital portion. Caroline pointed to the trust, which listed the business as a trust asset and directed proceeds to the beneficiaries. The judge ordered the escrow agent to release funds to the trust and then to distribute per the trust equally to me and Evan minus the spousal allowances and administrative expenses. It was not a fairy tale. We would pay fees. But the number on the whiteboard in my mind, the number that had been picked up and tossed like a ball in a backyard I no longer owned, finally started to land somewhere real. Second, the judge addressed the ongoing administration. She appointed a neutral fiduciary as co-trustee with Linda. Because Linda had used the power of attorney to try to rewrite Gravity, the judge would not let her be Gravity herself. The co-trustee, a woman named Marisol, with eyes that said she had untangled worse, took notes as if the notes would become a tiny courthouse, and we could all move in there to live by the rules we do not make. We are not done when a judge speaks. There are filings, notices, deeds to correct. The title company recorded an affidavit clearing the fraudulent deed from the chain. The house went back into the trust's name, and Linda had the right to live there for a period set by the trust amendment, 2 years, not forever. I still have the email where Dad asked his lawyer on October 5th, 2023, about a right to reside for Linda so she is not displaced, but ultimately the house goes to the kids. The amendment did exactly that. It gave Linda the right to live there until May 10th, 2026, if she paid taxes and maintenance. It said if she failed to do so for 90 days, the right could be terminated. That's not a cliff, it's a guardrail. She signed an occupancy agreement with the co-trustee. She called it humiliating. I called it paper. The consequences rippled outward, like the circles when a cinder block meets a pond. For Linda, it meant the renovations stopped. The paint swatches came down. The contractor cashed the $25,000 cashier's check and then returned $8,300 for work not done. The court ordered that refund paid to the trust. The posts on her Facebook shifted from joy to recipes. She stopped tagging the house. Some families would have turned that into a victory lap. I drove by once in August and watched a lawn service edge the sidewalks Dad had edged himself with a pocket knife. Justice doesn't always look like a parade. Sometimes it looks like a trimmed line where grass used to spill over concrete. For Evan, the money translated into something as solid as a roof. He had been making rent on a place with a LEED inspection certificate framed like art next to the stove. He texted me a photo on September 3rd, keys on his palm, escrow documents on the counter of a starter home out in Huber Heights. The purchase price on the closing disclosure was $229,000. His down payment was $45,800, and the loan terms were not awful. He cried, and I didn't try to stop him or myself. I sent him a set of nesting bowls that fit inside each other like the way our lives used to fit into a house before someone tried to sell it out from under us. For me, the consequences were a new kind of quiet. When the co-trustee wired my share of the $450,000 less fees, $203,700 after attorneys, recording costs, and the spousal allowance shaped like an orange cone you have to drive around, I paid off my credit card balance that had ballooned during Dad's illness. I bought a used Honda CR-V with 58,000 miles, because when you fight a fight like this, you learn to love cars that start. I took 3 days off from the channel and went to a motel outside Yellow Springs, where the vending machines still take quarters. I sat on the bed and watched a local news broadcast where the top story was a county fair ribbon scandal, and I ate peanut M&Ms and drank bottled water. That's what victory tasted like. It was not champagne. It was a vending machine that did not jam. The law always wants more from you. There were accounting reports to review, a pile as high as the stack of sympathy cards. I learned to read them in the same voice I use to narrate my videos. Slow, warm, unafraid. On October 12th, I signed a receipt and release for the first partial distribution, and I noted that the trust retained the house until the right to reside ended. I did not scribble on the margins about how I wished Dad had written 3 more sentences, or that he had not been careful in the way we needed, earlier, louder. He did enough by being himself. A man who wrote lists and wanted his kids to have the business proceeds because they had carried window units upstairs in July when the Ohio air was a heavy coat you couldn't take off. As for Linda, the consequences were complicated, and that is a word that tastes like cardboard. The court did not drag her to jail. It did something better. It wrapped her in paperwork. The co-trustee required monthly proof of paid taxes and insurance, receipts for maintenance, and a site visit each quarter. When in November we learned she had missed the October property tax installment, Marisol gave her 30 days to cure. Linda cured it. The magic was not that she suffered. The magic was that the law took my father's intentions, the ones spoken into a phone at 8:12 p.m., and made them thicker than a Facebook post. We still have a family, in the way that a quilt hanging in a museum is still called a quilt, even if no one is sleeping under it anymore. Aunt Ruth calls me and asks if I'm eating enough. Evan invites me over to watch the game, and we both pretend that without Dad yelling at the TV, any of it matters. At Christmas, Linda sent a card with a winter scene on the front. Inside she wrote, "I hope you are well." She did not write, "I'm sorry, I did not ask her to." Some apologies are a kind of theatre, and I'm in the business of what can be proved. There is a moment on our second court date that I haven't told you about yet. It's the moment I carry around like a spare key. Right before the judge read her order, she looked at me and then at Linda, and then at the copy of the power of attorney on the desk. She said, "Powers given in writing are bounded by that writing. Love and $10 is a phrase. This is a court." She did not smile. But it felt like a smile to the part of me that used to believe outrage was the only weapon. The weapon that worked was boring. It used section numbers and dates and an agent's duty that has been in the law longer than any of us have been angry. If you are listening because you are in the middle of your own kitchen war, here is the plan I would hand you on an index card. Gather the documents, the will, the trust, any schedules, deeds, and the power of attorney. Learn the difference between a pour-over will and a trust schedule. Look for explicit authority for self-dealing. If it's not there, hold that absence like evidence. Get recordings of intentions where you can, but do not manufacture drama. Let the facts carry their own voltage. When you walk into a courthouse, remember you are not there to prove you loved someone. You are there to show what the paper says. That's the whole trick. That's the whole miracle. On the channel, I cut the story into 3 videos. Part 1 is the funeral and the deed. It ends with me standing in my car, holding the power of attorney in the recorder's office parking lot, whispering into the mic, and then I saw the clause nobody expected. Part 2 is the first hearing and the recording, and it ends with the judge setting a briefing schedule that felt like a cliff edge we might actually survive. Part 3 is the order and the aftermath. I filmed the third one in my kitchen with the blinds open because shame loves dark rooms and I don't. I held up the order like people hold up sonogram photos. I didn't cry on camera. I saved that for when I got the email from Evan with his closing photo. He didn't cry on camera either. We're our father's kids. We do the work and then we breathe. There are questions I still get, and they land in my inbox like paper planes folded by hands that have been shaking all day. Why didn't your dad see this coming? He saw some of it. He wrote a will and a trust, and he told me about Schedule B. He trusted the person who was supposed to love him, and sometimes love and law are parallel lines that never meet without a judge. Why didn't you just let her have the house? Because the trust didn't. Because my brother and I were on a list my dad made when his hands still smelled like Freon and coffee, and I don't walk away from lists like that. Because the story you tell yourself about being generous can be a mask you wear to cover cowardice, and I am done wearing that mask. I keep the certified copy of the order in a fireproof box now, with my passport and a photo of Dad wearing a cap with the heart heating logo. On bad nights, I take it out and read the wherefores and the heretofores and the tiny typeset date, July 16th, 2024, and I remember that a system that can feel like a brick wall can also be a door if you know the hinge. I don't pretend it fixes everything. There are silences now where there used to be Sunday dinners. There is a Christmas stocking with Linda's name on it in a box in my closet that I don't know what to do with. There is the knowledge that goodness is not a strategy, and strategy is not a sin. One more thing, because you've stayed with me this long. After the second hearing, when we were gathering our bags and our breath, the title rep who'd been sitting in the back came up to me. She said, "I came because I saw the deed and it felt wrong. Thank you for bringing the schedule." I said, "Thank you for smelling the smoke." She handed me her card and said, "Call me if you need anything recorded." It was such a small sentence, nothing like a parade, and yet it felt like the sound of a community you don't see until the lights come on. Justice is not alone, it just hides. My name is Emily Hart. I tell stories on After Her Lies not because I enjoy tearing people apart, but because the truth stitches lives together in ways that secrets never can. Today, the residence at 215 Willow Bend belongs to the trust that will ultimately hand it to me and Evan, the way our dad wanted when he wrote Schedule B and asked the paralegal to staple it firmly so it wouldn't get lost. Today, Linda lives there under an agreement that looks like a leash. Today, my brother makes coffee in a kitchen that smells like paint and hope. Today, I am telling you a story that is yours too, if you need it. 96% of the people who watch these videos aren't subscribed, which means most of you will walk away without the one click that keeps this kind of story moving. If this helped you, subscribe to After Her Lies, like the video, so it reaches someone who's staring at a deed with love and $10 on it. And tell me in the comments what clause or recording turned your story around.